Chapter 24, Employment and Discrimination Law, Part 2, presented by Kelly Herzig. In Part 2, we will cover additional laws governing the employment relationship, employee privacy in the workplace, social media use in employment decisions, responsibility of employers in hiring foreign workers, and labor laws and unions. We will begin this lesson with additional laws governing the employment relationship. Several major state and federal laws govern employee rights with regards to wages, benefits, and health and safety standards. They include the Fair Labor Standards Act, Family and Medical Leave Act, unemployment compensation and workers' compensation at the state level, the Consolidated Omnibus Budget Reconciliation Act of 1985, the Employment Retirement Income Security Act of 1974, and the Occupational Safety and Health Act of 1970. Next, we will discuss the Fair Labor Standards Act, the FLSA. The Fair Labor Standards Act requires a minimum wage of a specified amount to be paid to all employees in covered industries. Congress raises the minimum amount periodically to cover cost of living increases due to inflation. The current federal minimum wage is $7.25 per hour. However, tipped employees like wait staff are paid $2.13 per hour as long as they receive at least $30 per month in tips. If wages and tips do not equal the federal minimum wage of $7.25 per hour during any given week, the employer is required to increase cash wages to compensate. Currently, 29 states, plus the District of Columbia, Guam, and the U.S. Virgin Islands, have a state minimum wage greater than the federal minimum wage, ranging from $8.25 in Guam to $14 an hour in the District of Columbia. There are 21 states, plus Puerto Rico and the Northern Mariana Islands, that either have no minimum rate, which is 5 states in the South, or have a lower or equal rate compared to the federal rate, meaning the federal minimum wage of $7.25 per hour generally applies in all these states. In Kansas, the minimum hourly rate is $7.25, the same as the federal wage. Now, the FLSA does not cover everything to do with wages. For example, it does not require vacation, holiday, severance, or sick pay, meals, rest periods, holidays off, or vacations. It does not require premium pay for weekend or holiday work, pay raises or fringe benefits, or a discharge notice, reason for discharge, or immediate payment of final wages to terminated employees. While the FLSA doesn't provide for the types of wages I mentioned on the previous slide, it does provide for overtime pay. The FLSA provides for overtime pay at a rate not less than 1.5 times the regular rate of pay after 40 hours of work in a given work week. The FLSA also governs child labor laws. I'm not going to go into all the child labor laws. What you need to remember is that at age 16, there are no limits on work hours. There's no minimum number of employees needed for an employer to be subject to the FLSA. Rather, the FLSA applies to companies whose sales are $500 or more in a given year. It applies to hospitals, businesses providing medical or nursing care for residents, schools and preschools, and government agencies, or those who are engaged in interstate commerce. The reality is that most every business is covered by the FLSA due to the interstate commerce prong. Courts have interpreted the interstate commerce requirement very broadly. For example, courts have ruled that companies that regularly use the U.S. mail to send or receive letters to and from other states are engaged in interstate commerce. Even the fact that employees use company telephones, email, or computers to place or accept interstate business calls, or order supplies, or even take orders, has subjected an employer to the FLSA. There are a few employers that are exempt from FLSA coverage. They are very small businesses, usually sole proprietorships with no employees, small newspapers, some seasonal businesses, or farms that use relatively little outside paid labor. Domestic service workers, such as day workers, housekeepers, chauffeurs, cooks, or full-time babysitters, are covered if their cash wages from one employer in the calendar year 2020 are at least $2,200, or if they work a total of more than 8 hours a week for one or more employers. So if you hire a babysitter part-time, or a cook, or a maid, you need to find out how much they're making a year, and are they working more than 8 hours, not just for you, but for other people, to see if you owe them minimum wage. There are 4 categories of workers that are excluded from FLSA coverage. They're executives, administrative employees, professional employees, and outside salespersons. The next major employment statute is the Family Medical Leave Act. The Family Medical Leave Act, FMLA, was enacted in 1993. The FMLA covers all public employers and private employers with 50 or more employees. Employees are eligible for FMLA coverage if they have worked at least 25 hours a week for each of 12 months prior to taking leave. The FMLA provides eligible employees up to 12 weeks of unpaid leave. That's very important. It's unpaid during any 12-month period of any of the following family occurrences: the birth of a child, the adoption of a child, the placement of a foster child in the employee's care, the care of a seriously ill spouse, parent, or child, or a serious personal health condition that renders the employee unable to perform any of the essential functions of his or her job. Next, we will discuss unemployment and workers' compensation laws. The Federal Unemployment Tax Act, FUTA, passed in 1935, created a state system to provide unemployment compensation to qualified employees who lose their jobs. Employers pay taxes to the states, which deposits the money into the federal government's unemployment insurance fund. Each state has an account from which it can access money from the fund to pay unemployment claims based on state eligibility rules. Now, states all have different rules, but almost all states block eligibility if an employee voluntarily quits or gets fired for cause. States also have workers' compensation laws to provide compensation for eligible workers injured or killed on the job. Generally, if an employee receives workers' compensation benefits, they cannot sue their employer for injuries unless there is an intentional tort, reckless misconduct, or the employer lacks adequate workers' compensation insurance. However, there are certain types of businesses and small businesses that are excluded from coverage. Now, during this pandemic, there has been some legislation that has impacted unemployment. On March 18, 2020, President Trump signed into law the Families First Coronavirus Response Act, which provided additional flexibility for state unemployment insurance agencies and additional administrative funding to respond to the COVID-19 pandemic. The Coronavirus Aid, Relief, and Economic Security Act was signed into law on March 27th this year. It is the largest economic stimulus package in U.S. history. In addition to the stimulus payments to individuals and small business loans, the CARES Act expanded states' ability to provide unemployment insurance for many workers impacted by the COVID-19 pandemic, including for workers who are not ordinarily eligible for unemployment benefits, like independent contractors. However, the extra unemployment benefits expired July 26, 2020, and this was not extended by Congress. Next, I want to discuss the Consolidated Omnibus Budget Reconciliation Act of 1985. The Consolidated Omnibus Budget Reconciliation Act of 1985 is known as COBRA, and it ensures that employees who lose their jobs or have their hours cut to the extent that they are no longer eligible for medical, optical, or dental insurance, they can continue to receive benefits for themselves and their families under the employer's policies. To retain coverage on the employer's plan, the employee must pay the premiums for the policy plus up to a 2% administrative fee. It can be very expensive. This benefit is available for 18 months for an employee, or if the employee is disabled, for up to 29 months. An employee has 60 days from the date of termination to opt into coverage under COBRA. However, COBRA is not available if the employee is fired for gross misconduct or if the employer eliminates benefits for all employees. Now, rather than take COBRA due to its expense, many people elect to get coverage on the Affordable Care Act exchange in their state because losing a job is a qualifying event that will allow enrollment outside the open enrollment period. In addition, they may be eligible for tax credits depending on their income level, and it can subsidize their monthly insurance premiums. The reality is that COBRA is sometimes prohibitively expensive for people, and the Affordable Care Act exchange is just a better option. Next, we will cover the Employee Retirement Income Security Act of 1974. The Employee Retirement Income Security Act of 1974 is known as ERISA. It is a federal law that sets minimum standards for most voluntarily established pension and health plans in the private sector. Under ERISA, employers must provide the following to participants: plan information like features and funding, assurances of the fiduciary responsibility of those in charge of managing and controlling plan assets, a grievance and appeals process for participants to get benefits from their plans, the right to sue for benefits and breaches of fiduciary duty. Employers are required to provide to employees free of charge a summary plan description called an SPD, which provides information on how the plan operates, plan benefits, how to apply for benefits, when benefits vest, and when benefits may be paid out. Next, I want to discuss the Occupational Safety and Health Act of 1970. The Occupational Safety and Health Act of 1970 is known as OSHA, and it regulates workplace safety. The OSHA statute requires employers to furnish employees with employment free from recognized hazards that are likely to cause death or serious bodily harm. OSHA established the Occupational Safety and Health Administration, also known as OSHA, which is a federal agency responsible for setting workplace safety standards. OSHA as an agency enforces the standards it sets for workplace safety, health, and sanitation by inspecting facilities to ensure compliance with the standards. OSHA also undertakes educational programs for employers and employees. OSHA is also empowered with bringing enforcement actions against violators and can levy fines. Now, OSHA has 6 months to issue a citation after an inspection. If employers feel they have been cited unfairly, they can contest the citation within 15 days. That's a hard deadline. If you fail to contest the citation within 15 days, you have very little recourse. But if you do contest the citation, an independent commission known as the Occupational Safety and Health Review Commission hears the protests. Now, employers that are consistently non-compliant can be summoned into court and become subject to court orders regarding their operations, including orders to fix the problems before resuming business. They can become part of the Severe Violators Enforcement Program and basically get called into federal court for enforcement under Section 11B of the OSHA Act. Most private sector employers and the United States Postal Service are covered by OSHA, though there are some exempt employers. Generally, self-employed individuals, churches, federal and state governments and their political subdivisions, businesses regulated by different federal statutes such as nuclear power and mining companies, domestic services employers, businesses that do not engage in interstate commerce, and farms that have only immediate family members as employees are exempt from OSHA standards and record keeping. If a business maintains 10 or fewer employees throughout a calendar year, it is exempt from OSHA record-keeping requirements only. It does not need to keep OSHA injury and illness records, although the business must file OSHA reports if fatalities occur or more than 3 employees are hospitalized within a calendar year. Industries in retail service, finance, insurance, and real estate sectors that are classified as low hazard are also generally exempt from OSHA record-keeping requirements only. In the next 2 slides, I've created a summary, a key summary of the significant employment laws we just went over. The first, of course, were the wage and hour laws. They're federal and state laws that impose minimum wage and hour requirements for employees. Then there's the Family Medical Leave Act, which is a federal law requiring certain employers to provide eligible employees with up to 12 weeks unpaid leave during any 12-month period for several family-related occurrences. Then there's unemployment compensation, which is the state system created by the Federal Unemployment Tax Act that provides unemployment benefits to qualified employees who lose their jobs. The next significant employment law that we discussed was COBRA, which was the federal law that protects employees who lose their jobs or have their hours reduced to the point they lose medical, optical, or dental insurance by ensuring those employees can remain on the employer's insurance for up to 18 months, but they must pay policy premiums. Then there was ERISA. This is the federal law that sets minimum standards for most voluntarily established pension and health plans in the private sector. And finally, we discussed OSHA, which is the federal law that established OSHA, the agency. It empowers OSHA to inspect for unsafe or unsanitary working conditions and fine violators. Next, I want to briefly discuss employee privacy in the workplace. As you may recall, private employers are not constrained by the Fourth Amendment, and generally, employees have less privacy rights at work than they do at home. In Chapter 5, Part 2, we covered the employer's right to search physical offices and workspaces, company-owned computers, emails, and text messages on company phones, which courts have routinely allowed because employees have no reasonable expectation of privacy in these areas or equipment when they're searched. So I want to discuss one specific area, mostly having to do with employee telephone calls. There are some protections for and limitations on employee telephone calls at work. Under the Omnibus Crime Control Act and Safety Streets Act of 1968, employers cannot listen to employees' private telephone calls or disclose their content. Under this act, employers can ban personal calls and can monitor calls for compliance, though they must stop listening once the call is determined to be personal in nature. Under the Electronic Communications Privacy Act of 1986, employees' privacy rights were extended to electronic forms of communication such as email and cell phones, though employers can monitor these forms of communication in the ordinary course of their employment, but they must stop monitoring if it is clear that the call or email is personal. The key is whether the employee has a reasonable expectation of privacy in the communication. Employees can consent to monitoring of their telephone calls. Personal cell phones cannot be searched generally unless the employee consents. Though courts have found that employees generally have no expectation of privacy on company-owned computers and phones, including company cell phones, a prudent employer will have a written privacy policy. A written privacy policy should lay out that employees have no expectation of privacy in the workplace, offices, desks, company computers, company cars, company cell phones, and company emails. The privacy policy should lay out company policy on monitoring or surveillance, employee access to medical and employee records, policies on lie detector or drug testing if applicable, and company ownership of all equipment and records. Employees should be asked to sign that they have read and been provided these policies. Next, I want to discuss social media use in employment hiring decisions. Companies often check a prospective employee's social media accounts during the hiring process. However, any information obtained from the candidate's social media that falls into protected categories such as age, race, ethnicity, religion, and disability must be ignored during the hiring process. That can be difficult to do, so a lot of times they hire third-party companies to conduct these searches. Employers should bear in mind, however, that background screening companies that use social media sites are subject to the provisions of the Fair Credit Reporting Act, which requires that applicants give permission for pre-employment investigations. Asking an employee candidate for permission to use a password to access social media platforms like Facebook's can be prohibited by or at least restricted under state law in some states. You need to check state law before you ask for someone's password. Using social media like LinkedIn to find candidates can be problematic because of the underrepresentation of minorities on those sites. This type of hiring can create a disparate impact on a protected class and could subject the employer to liability. Next, I want to discuss social media use in employment firing decisions. Using social media activity as a basis for a firing decision can depend on the manner in which the employee is using social media. The National Labor Relations Act, the NLRA, protects the rights of employees to act together to address work conditions with or without a union, which extends to certain work-related conversations conducted on social media. Employees are allowed to initiate group action discussions on topics protected by federal labor laws, such as working conditions or wages, and they can do that on social media, and employers cannot restrain that right. However, individual complaints or comments not aimed to induce group action are not protected. The bottom line is that employers can use social media in employment decisions, but should take care not to run afoul of state and federal employment and labor laws and regulations. Next, we will discuss the responsibilities of employers in hiring foreign workers. Until 1986, there was virtually no risk to employers who hired undocumented immigrants. However, in 1986, Congress passed the Immigration Reform and Control Act, which amended the Immigration and Nationality Act, the INA. The IRCA requires employers to verify the identity and eligibility of all individuals hired in the U.S. after November 6, 1986. Under the INA, employers must document each employee's status by filling out INA Form I-9, the Employment Eligibility Verification Form. The U.S. Customs and Immigration Service, USCIS, has an employer's handbook published on its website that details an employer's legal obligations and explains how to fill out the required forms for each employee. The federal agency responsible for immigration worksite enforcement is Immigration Customs Enforcement, known as ICE. Knowingly hiring undocumented immigrants will subject an employer to both civil and/or criminal penalties. As of 2019, civil penalties begin at a minimum of $573 per worker for a first offense and from $4,586 or more per employee for employers who have a pattern or practice of hiring undocumented workers. These employers can face prison terms of up to 6 months. Your book does not have the most current penalty numbers. These are the most current penalty numbers. If an employer unknowingly hires an undocumented immigrant, liability will turn on whether the employer did their due diligence in reviewing an employee's work authorization papers. Employers are not expected to be experts on the documents that establish work authorization, but they must make a good faith effort to ensure their employees are legally able to work in the U.S. An employer can accept documents that on their face reasonably appear to be genuine and relate to the person presenting them. Employers are also required to retain I-9 forms for 3 years or 1 year after the employee leaves his or her employment, whichever is longer. Form I-9 paperwork violations start at $230 and can go up to $2,292 per violation as of 2019. The last major topic we're going to cover in this chapter are labor laws and unions. Some of the most important employee protection laws involve the right to organize as a union and bargain collectively over wages and other terms and conditions of employment. Union membership in the United States has waxed and waned over the years. Post-World War II, about 1/3 of workers belonged to a union. In the last decade, union membership has shrunk and has hovered between 10% and 11% of all workers. It was 10.3% in 2019. In the public sector, local government workers, teachers, police, and firefighters have higher percentages of workers in unions. In the private sector, industries with higher union membership include utilities, transportation, warehousing, telecommunications, and construction. Labor management relations are governed by 3 major laws: the Wagner Act of 1935, the Taft-Hartley Act of 1947, the Landry-Griffin Act of 1959. The Wagner Act, as amended by the Taft-Hartley Act, are referred together as the National Labor Relations Act, the NLRA. Next, we will cover the major labor laws we just discussed on the previous page. The Wagner Act of 1935 was the first federal labor law to explicitly encourage the formation of labor unions and provide for collective bargaining between employers and unions to peacefully settle labor disputes concerning the conditions and terms of employment. It also created the National Labor Relations Board, the NLRB, to interpret and enforce the NLRA, and it also allowed for judicial review of NLRB decisions in certain federal courts. The Taft-Hartley Act of 1947 is also known as the Labor Management and Relations Act. It was passed to curtail some powers of unions acquired under the Wagner Act, and it designated some union actions as unfair and required disclosure of certain financial and political activities of unions. The Landry-Griffin Act of 1959 governs the internal operations of labor unions. The act was passed in response to evidence of certain undesirable union practices, such as corruption and autocratic operation methods. It requires public disclosures of union financial information and establishes civil and criminal penalties for financial abuses by labor union officials. It contains a labor bill of rights for all union members on collective bargaining and selecting their representation in unions. The final topic we're going to discuss today is the NLRB and collective bargaining. The NLRB is the federal administrative agency that enforces and interprets the NLRA. Its 3 primary functions are to monitor the conduct of the employer and the union during an election to determine whether workers want to be represented by a union, to prevent and remedy unfair labor practices by either employers or labor unions, and to establish rules interpreting the NLRA. The NLRB has jurisdiction over all employees except those employed in federal, state, or local government, and those covered by the Railway Labor Act, which is employees in the transportation industry. They also don't cover independent contractors, agricultural workers, household domestics, persons employed by a spouse or parent, and supervisors, managerial employees, and confidential employees. Now, once a union has been certified, the NLRB can order the union and employer to bargain in good faith about hours, wages, and other terms and conditions of employment. They cannot order the parties to reach an agreement or force a contract term or on a whole contract on either party. This is the end of Chapter 24, Part 2.